Any mention?
Right.
Yes, yes.
Item number 20, my lord.
20.
Yes, my lord.
Why?
Supposed to file this affidavit,
Okay.
but it is not ready. After
Yes,
2
1
weeks,
week. Yes. Quick.
my lord.
Lordship, I crave indulgence to move a mention memo for resting tomorrow, my lord.
What matter?
It's a matter regarding appointment in Nehu, my lord.
Why? What's the urgency?
Urgency is, my lord, someone has been appointed, but as per instructions, he's still not yet confirmed. So let it come up tomorrow, my lord.
It's already filed.
Lordship, I also beg to mention item 23. For the petitioner, my lord, I'm praying for next week.
Why keep on adjourning this matter?
No, it's a fresh matter, my lord. Listed for the first time for hearing.
1 week, yes.
Lordship.
Yes, Mr. Jha. Yes.
May I please, Lordship? The interim order may be continued in 23, my lord. Interim order in
You
20.
adjourn and interim order goes.
Kindly, my lord.
You take that either way.
Otherwise, we'll do it. Next week, my lord.
Okay, 1 week. Interim order continue next week.
Much obliged, Lordship.
Yes, Mr. Chanda.
My lord, 18 and 19, I'll do it in the physical court, my lord.
Okay. 18, 19.
18,
The
19,
request
2
of
weeks,
Mr. M. Chandra appear personally. Just a matter after 1 week, yes.
My lord, item number 42.
Obliged.
42, my lord, we are withdrawing the
Yes?
petition, my lord.
Withdrawing it, yes, 42. And the request also, please allow to withdraw. Matters disposal withdrawn, yes.
May it please Your Lordship, I beg to make a mention of item number 21, Your Lordship. Lordship, I'm for the petition. In this matter, Your Lordship, I directed them to seek instructions with regard to the notification, this remusteration matter. Your Lordship,
No instructions.
not yet. We have not yet received an instruction, Your Lordship.
No, 1 week,
My Lord.
you get instruction next date.
Yes, Your Lordship.
You remember that is supposed to instruction by next date.
Yes, my Lord. It will be the third occasion. Much obliged, Lordship.
Yes.
May I please, Your Lordship, I beg to mention item 25. It's connecting matter to 35, Your Lordship.
25 to 35?
Yes, Your Lordship.
Why?
It's the conducting counsels indisposed, Your Lordship.
Indisposed?
Yes.
2025. As the learned senior counsel said, still we indisposed this matter after 1 week.
Much obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 24, Lordship. I am appearing for respondent number 428, Lordship. I have taken the consent of the petitioner, Lordship.
2 weeks, yes. 20.
I'm appearing for respondent 11.
2 weeks, yes.
Highly obliged.
I'm for respondent 9.
Very good. Correct their names, yes.
Please, Your Lordship. Lordship, I beg to mention item number 38.
20?
38. Lordship, 38, I'm appearing for the state.
Yeah,
Respondent
objection.
number 1 to 3. My Lord, at least they should have informed yesterday. Luckily, today I have quite many matters, so it was not a difficulty.
She wants to do it, so you ready?
No, Your Lordship.
The long matter, small matter.
Short matter, my Lord. It's
Then?
just...
The conducting counsel is not here, Your Lordship.
Who's going to counsel?
It's from Guwahati.
He's from Guwahati. He was...
Doesn't matter. Doesn't excuse.
She's also not signatory to the Wakalatnama.
Oh,
I'm there. No, I'm there in the Wakalatnama. Yes.
okay. When other matters 1 week, yes.
My Lord, obliged.
Yes.
Your Lordship, item number 6, the Miss Sylvia Nossi will appear through VC.
Who?
Miss Sylvia Nossi will appear through VC as Nossi.
You don't need to mention it. Will be called out. They can appear. Yes. Yes, Mr. Thomas. Any special request?
Arguments are over. Only a small rejoinder, so I may be allowed to argue today. I'm obliged.
I beg to mention item number 41, my lord. This is that Nehu matter, my lord. My lord, the affidavits are on record, my lord. I'm praying for 1 week time to file the
No,
rejoinder.
but there's a special request by a senior that.
My lord,
we
the
have to
affidavit
get.
last affidavit is filed on the 5th of March, my
So
lord.
let us do it today. You're there.
My lord, I'm praying for a 1
Who's
week
appearing
time.
for Nehu?
She's...
You ready?
My lord. Short affidavit, my lord, rejoinder affidavit is required, my lord, to be filed, my lord.
Then take 2 weeks, yes. You should come again after 1 week for rejoinder for sure.
No, my lord, we'll file it in
Yes, sir. MS, another place for around 2 weeks time to file rejoinder after filed by respondent number.
All the respondents, my lord.
Respondent, just after 2 weeks, yes. Yes. Again.
Yes, Your Lordship. Item number 36, Your Lordship.
Sebastian,
Yes, Your Lordship.
who's of other side?
Sir M. Chanda, Your Lordship.
Other sides whom?
Sir Chanda, Your Lordship.
On whose behalf you're mentioning?
On behalf of Dr. and Muzika, the Leonard DH.
Okay, after 2 weeks, yes. 25, 35, 36. Okay. Yes.
Daily list, item number 1.
May it please, Your Lordship. It's a contempt or violation of the order of learned arbitrator, my lord.
Arbitrator?
Learned arbitrator, my lord, under section 27(5) of Arbitration and Conciliation Act, my lord. For breach of the order of learned arbitrator, my lord, contempt lies with the High Court, my lord. Kindly see the order, my lord, at page 9.
Arbitral Tribunal?
Arbitral Tribunal's order, my lord.
Page?
Page 9.
Yes.
And the order is, my lord, there was a direction and paragraph 2, my lord. Paragraph 2 at page 9 is the order, my lord.
19 or 9?
9. What? Simply 9, my lord.
Okay, sorry. 9.
19 February order, my lord. An application is filed by respondent number 1, State of Meghalaya, praying for initiating contempt proceeding against the claimant for non-compliance and disobedience of the order dated 18th November 23, read with the order of 10th October 23, passed by the tribunal.
Yeah.
And then thereafter this order has not been complied, my lord, and kindly see paragraph 4.
Yes.
We have heard parties in this application, counsel for the claimant on instruction received, who is personally present, that claimant is unable to comply with the aforesaid directions of tribunal for some reason. In our considered opinion, the stand taken by claimant cannot be appreciated. We feel that the non-compliance of such interim order passed by tribunal, including direction to pay lease rental amount as due and payable despite being in admitted possession of the project property, is in total defiance and disobedience of the order of the tribunal. The effect of this order on the arbitrator will be considered later. But at this stage, we are of the considered opinion proceeding under the Contempt of Court Act is required to be drawn up against the company and the person responsible for running the claimant company. Since the tribunal does not possess the power and jurisdiction to take action under Contempt of Court Act, yet we feel the matter would require strict action. Therefore, we contempt proceeding to be taken up by the Honorable High Court of Meghalaya. We therefore refer the matter to registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary order for doing the needful in the matter. Matter shall be placed along with the order relevant document we may fill out. So, my lord, the law in this regard is very, very clear. The Honorable Supreme Court, in the case of, my lord, it has Alka Chandevar, Justice Nariman's order, saying that the order of the tribunal, if not complied, it will be contempt of the order of the court, and the High Court has jurisdiction to initiate the contempt.
Judgment? Yes.
Kindly see the paragraph 1, my lord. First, the facts are identical. The leave granted. The present appeal arises from the judgment of Bombay High Court dated 27th October 2015, in which the High Court has construed section 27 subsection 5 of Arbitration and Conciliation Act 1996 in somewhat restrictive manner. Facts necessary to appreciate the point involved in this appeal are that on 7th October 2010, sole arbitrator appointed by parties passed an interim order under section 17 of the said act, in which it was mentioned that no further flats will be disposed of without the leave of the arbitral tribunal. In breach of this order, it is alleged that on 14th October 2010, the respondent in fact transferred 5 such flats. By order dated 23rd March 2012, it was held by the learned arbitrator that the order of 7/10/2000 had in fact been breached by the respondent, and certain other directions were made by the aforesaid order. Ultimately, by order dated 5th May 2014, learned arbitrator referred the aforesaid contempt petition of the order of 7th October to the High Court to pass necessary order.
27.5 is for procedure, correct? What is...
No, because this is the 27.5 contemplates both the aspect, procedure also, and this is what it has been discussed, my lord, in this case, my lord. Because Bombay High Court took the view that no contempt is made out under 20 because the 27(5) is meant for procedure, my lord. If you lordship will see para 2 of the Bombay High Court judgment also. In the judgment under appeal, High Court held, in view of the above discussion, Section 27, subsection 5 of Arbitration and Conciliation Act does not empower the tribunal to make representation to the court for contempt if the orders, including interim order passed by arbitrator, except in respect of taking evidence, are violated by party. Contempt petition being the representation made by the tribunal is beyond the period of limitation and is not maintainable law. However, final award is granted in favor of the petitioner by the arbitrator. We heard the learned counsel parties, Mr. Nafde, Mr. Marpalle, learned senior counsel appearing on behalf of the appellant, has argued that Section 9 and 17 being alternative remedies available to the parties before the tribunal if the orders made under Section 17 are unenforceable, they would mere ropes of sand as a result of which the provisions would be rendered OTOs. He also argued that Section 27 of the Act does not leave any doubt as to the scope and ambit of the court's power to punish for contempt of the order made by the arbitral tribunal. He also relied upon High Court judgment and judgment delivered by Maruti Udyog Limited, Maninder Singh Mehta. And then, my lord, the court, after quoting the relevant provisions, my lord, kindly see paragraph 6 at page 123, my lord.
Yes.
If Section 27(5) is read literally, there is no difficulty in accepting the plea of the learned senior advocate for the appellant because persons failing to attend in accordance with court process fall under separate category from any other default. Further, this section is not confined to a person guilty of contempt only when failing to attend in accordance with such process. This section specifically states that persons guilty of any contempt to arbitral proceeding, tribunal during the conduct of arbitral proceeding is within the ken. The aforesaid language is in fact in consonance with chapter heading the chapter Conduct of Arbitral Proceeding. Further, it is well settled that marginal note can be used as internal aid to interpretation of statute only in order to show what is generally drift of the section. It may also be resorted to when the plain meaning of the section is not clear. In the present case, we must go to the plain meaning of subsection 5. This being the case, we find difficulty to appreciate the reasoning of the High Court. Also in consonance with modern rule of interpretation of a statute, the entire object of providing a party may approach the arbitral tribunal instead of court for interim relief would be stultified. If interim order passed by tribunal are toothless, it is to give teeth to such orders and express provision made under Section 27(5) of the Act. In fact, Delhi High Court, by judgment of reported in Sri Krishna versus Anand, has correctly construed Section 27(5) of the Act. Further, it must be remembered that Ambalal Sarabhai Limited versus has held that parties to arbitral proceedings are put an election to apply, my lord, and these judgments, my lord, have were to be written. So therefore, my lord, interim order passed by were to be written in a water all parties would then go only to the court, which would render the Section 17 a dead letter. And therefore, my lord, the Honorable Supreme Court said that 27(5) confers power on this Honorable Court to issue contempt jurisdiction in case of breach of the order. And if your lordship will see the order of the Delhi High Court, which has been approved, my lord, 2009, this Sri Krishna judgment, my lord, which has been approved in paragraph 8.
It is the first for this court. I've not seen this matter like this.
Yes, your lordship. This is the first matter, my lord. Paragraph 7, if your lordship will see, same judgment. In fact, Delhi High Court judgment dated 1882 reported in Sri Krishna Anand.
Okay.
Yes, my lord. And this has been approved, my lord.
Paragraph?
And paragraph, if your lordship will sort judgment, my lord.
Paragraph, oh, yeah, okay.
Paragraph 9, my lord. 8 and 9, my lord. However, in the present case, petitioner is claiming the identical relief from court under Section 9 as already availed under in Section. Only justification thereof is enforceability of the order granted under Section 9 and non-enforceability under Section 17. Because, my lord, I have the remedy to approach your lordship under Section 9 and I have the remedy to approach the arbitral tribunal under Section 17. At the outset, I may state that if able to find an answer to grievance raised by petitioner of the order under Section 17 being unenforceable and toothless, I am reluctant to hold that such repetition of orders can be sought from the court. Such an interpretation would make Section 17 OTOs and redundant and open to floodgate of the court or to petition under Section 9. Legislative intent in Section 17 of the Act appears to be make the arbitral tribunal a complete fora, not only for finally adjudicating the dispute within the party, but also order interim measures. If it were to be held to give teeth to the orders of Section 17, petitions under Section section 9 are to be filed, no purpose would be served in the parties approaching the arbitral tribunal first under section 17 of the Act, inasmuch as such a situation they might will approach the court directly under section 9. Both the courts as well arbitral tribunal ought not to be vexed with the same issue, not only at the expense their time but also at the cost of parties. Such interpretation which makes one of the provisions of statute meaningless has always to be avoided. In going through the Act minutely under such section 27(5) under the heading Court Assistance in Taking Evidence has been discovered, the same reads as under: persons failing to attend in accordance with such process or making any other default, my lord, or refusing to give the evidence or guilty of any contempt to arbitral tribunal during the conduct of arbitration shall be subject to like disadvantages, penalties and punishment by order of the court on the representation of arbitral tribunal as that they would incur for like offences in suit tried before this court.
But Mr. They will contest it for sure anyway. I heard the Lord Advocate General, assisted by so and so, issue notice. This is an application. The issue notice stop. This is an application under section 12 of the Contempt of Courts Act against alleged contempt for violation of the order of the arbitral tribunal dated
Your Lordship, the order
19/2/2024.
Yes.
Stop. Next paragraph. Issue notice returnable in 3 weeks. Steps to be taken by registered AD within 3 days. Yes. Just accordingly. Interesting.
Because the purpose is, my lord, if 17 order is passed and it is.
But can arbitral tribunal just file it directly to the High Court and say that now it's come via the parties, correct?
Yes.
But then, like, what is the modus operandi?
Because
usually can the arbitral tribunal directly request the registry of the High Court to place it before Chief Justice to take up as a contempt matter?
Because the order will be placed by the tribunal before the High Court, my lord.
Exactly.
The High Court thereafter will consider whether the order has been complied or not, if there is a breach or not, and then thereafter High Court will take a call whether contempt has been made out now. That jurisdiction is with this court only, my lord, under the Contempt of Court Act.
Yes.
Just one submission. The order which is in contempt is 8th and 10th of November
8th and 10th
2020.
November. I stand
8th and 10th of
8th and 10th of November.
23.
Yes.
23.
23.
Oh, please.
He's listening all along quietly. Yes, Mr. Marpan.
Please, Your Lordship, this is a contempt regarding the status quo. Following the passing of the status quo order, there were 2 letters,
Yes.
in fact 3 letters.
What status quo order was passed regarding movement?
Now,
what happened?
Just 5 days on 24th of February, the respondent number 5,
When
the
was the
contemptor
order
here,
issued for
had issued one order.
movement? When was it issued?
It was issued 5 days after the status quo order.
No, when was the order passed of this
19
16
February. 16 and the continuation is at 19, 3 days.
Yeah, Dr. Mozika.
My lord, I need instruction, my lord. If the matter comes the day after tomorrow, my lord.
Yes.
And also, I'd like to point it out, my salary also has been stopped.
Okay, they will take that up. Let him come to instructions. Mr. Esmalpan, issue notice. List a matter. Mr. Dr. Mozika, the DSG is present, along with so-and-so. This is after tomorrow for instructions, yes.
Right.
Tomorrow?
The matter is fixed. Tomorrow also it's there. This matter, the writ petition is listed tomorrow.
Tomorrow. Yeah, 2 o'clock. Yeah.
Item number 3.
Oh, Miss Habibi. Yes.
May it please your Lordship. Lordship, here the petitioner before your Lordship seeking direction from this Honorable Court to release the compensation for the damage of land as well as the trees.
It's already been acquired and computed.
Yes, Lordship, that is at Lordship, that is at page. That is at page 36, Lordship.
How much is the amount?
That for land they have
how
assessed,
big is the land?
Land that is only for one tower footing, Lordship.
Okay.
That is area would be 110 square meter, Lordship. This is for land, that serial number 4, Lordship.
110 square meters.
Square meter, Lordship. That serial number 4, Lordship.
Serial number 4. Rate per square meter.
Yes, Lordship.
So how much have you been paid?
Here they have assessed the damage for compensation for land is 5,78,502, and for trees, Lordship, that is at pace.
Your name is Romesa, so you have to get 6 lakhs.
And this is for land. And
Yes.
so far as trees, that is at pace 42, Lordship, the type copy, Lordship.
Who's appearing for the state?
Lordship, that Assam grid, Lordship, Assam electricity, but no one is appearing. On
Then?
Yes, Lordship.
Why are you not filing Guwahati then?
No, Lordship, because that
It belongs to whom, the project?
project belongs to that Assam Electricity Grid Corporation, Lordship.
And compensation was paid by the collector here?
No, Lordship. That is why, Lordship, that is why, as per the RTI, Lordship, that is at pace 48, Lordship.
Then becomes jurisdictional issue?
No, Lordship, because that thing, the cause of action arose at...
Doesn't matter. What is this? Not a question. Who was the person who disbursed the money?
That is at page 49, Lordship. That is why
Who
the
disbursed the
respondent...
money? Who disbursed the
The
money?
respondent number 2, Lordship.
You've got the money?
No, Lordship.
Where does it say that he's a disbursing authority?
Yes, Lordship. Since see, Lordship, that is at page 49. That is the RTI reply, Lordship. From that revenue, additional deputy commissioner revenue.
Where does it say?
See, clause 6, Lordship. Since the compensation to the beneficiaries has not been paid in this office, the required informations are not available with the office. The nodal department for payment of compensation in respect of these beneficiaries is Assam General Manager AEGL Gwalpara Transmission Line, Lordship.
AEGL is what? Agya.
Assam Electricity Grid Corporation Limited, Lordship.
You take a chance and we'll issue notice. Otherwise,
Yes, Lordship.
You consider it. Yes, heard. Says the Sheikh, issue notice returnable in. Why you not made then all the parties in Assam?
Yes, Lordship. Because since as per the reply I got from the deputy commissioner, they are saying that
Why did you arrange them as parties?
only we have assessed the land. Apart from we didn't pay anything because they have not deposited the compensation amount in the office of the deputy commissioner. So we are not aware
Anyway, I
of
will not give non-advisory jurisdiction. So anyway, this issue notice returnable in 3 weeks. Should take steps by said 80 within 3 days. List accordingly.
Item number 4.
May I please, Your Lordship? Your Lordship, I'm the petitioner here, actually, Your Lordship. I've been working under actually the Department of Home Affairs, Your Honor, and lastly I worked actually...
working under the Department of?
Home Affairs, Your Honor.
Home Affairs?
Yes, sir.
In
Meghalaya Police, and in the Superintendent of Police actually office.
Home Department?
Yes. In the MPRO Department, Your Lordship. So, Your Lordship, I got retired actually in the year 2004. So, thereafter actually, Your Lordship, after my retirement actually, this is annexure to my Lord. My first wife, she got actually expired. This is page number 11, my Lord.
Yes.
And thereafter actually I have become alone and there was no person to look after because from the first marriage actually whatever the child actually they have been separated from me. They have become major also and married. Thereafter I got my actually marriage with one Surula Burman, Your Lordship. This is page number 13, Your Lordship. This is type copy.
Yes.
And then actually, Your Lordship, I have applied actually to the, made a representation to the department concerned to the Superintendent of Police. This is annexure 4, my Lord, 17 and 18.
When you get married to this second wife?
Yeah, it is in 2010, my Lord.
So 6 years after you retired?
Yes, yes.
Immediately after your wife's death?
Yes.
Okay.
After the death of first wife, that is 4/11/2010, my Lord.
Yes.
And thereafter I have made a representation to the department, my Lord. This is page number 17 and 18, my Lord. To the Superintendent of Police MPRO.
Yes.
This is dated 13th October 2023, my Lord. Lastly, actually, I have made after my oral request. So I have gone actually submitted that one, but they are not actually considering only with a request that actually in my this is a service PPO. It should be my second wife's name and children. Two minor children are there. So their name should be included. Only is the request actually, but they are not actually exceeded with that.
They are children from your marriage?
Yes, second marriage, my Lord.
You have heard Mr. N.I. Chowdhury, correct?
Yes.
Issue notice returnable in 3 weeks. You accept notice on behalf of?
1 and 2.
Mr. S.C. Sheikh, Mr. President, accept notice on behalf of 1 and 2. And or 3 respondents only?
Oh, yes, Accountant General.
And MS E.V. Pasal number 3. Such notes complete. List after list on so and so for affidavit.
High Lord.
Item number 5.
Yes,
my lord, I'll have to withdraw this writ petition, my lord, in view of the subsequent development that has taken place. What has happened here is the NGT has taken suo motu cognizance of the
withdraw?
matter. Yes, my lord, I'll be withdrawing it.
You withdraw it with liberty to file afresh?
Yes, my lord.
This case becomes subject appraise he will be allowed to withdraw an instant petition for liberty to file afresh, if so advised. Accordingly, matter stands just for withdrawal, however, liberty as per it is.
Item number 6.
Yes.
My lord, the petitioner has applied.
Hey, focus the camera on your face. We're seeing half only. Yes. Yes.
May it please your lordship.
Yes.
The petitioner has applied for the post of counsellor issued by respondent number 1, which is at page 9, annex to 1, my lord.
Okay.
Serial number 3, post of counsellor.
Counselor. Graduate in social work.
Yes, my lord.
Okay. Then?
Graduate, yes. Yes, my lord. Then the petitioner has also been given the written examination, which is at annexure 3, page 13, my lord.
Okay, then.
Has also given the written examination, my lord. Then the petitioner has secured the second highest mark to the set post in the written examination. My lord, serial number 3, roll number 019.
Okay.
She secured the second highest mark.
Okay.
It is page number 13. Yes, my lord. It is a fact that the candidate who secured the highest mark in the written examination has not come for the interview mark. By the petitioner, top scorer at the time of the interview.
Okay.
My lord, when the final result was declared, which is at page 4, which is at page 5, annexure 4, my lord.
Okay. Councillor
Which is
Kelba
at-
Merinorum. Yes.
Yes, my lord. My lord, when the final results was declared, which is at annexure 4, page 15,
Yes.
has been given the appointment of councillor to respondent number 2.
What? How much
Despite,
marks?
my lord-
How much marks did she get?
My lord,
How much marks did she secure? This is respondent number 2.
they
How much?
did not disclose the mark of the personal interview, my lord.
Then you said this is the final marks. This is written examination
Uh,
marks.
my
she
lord,
was-
this is the final written
what is
examination mark. Yes, please.
how much marks were there for the interview? Let's see the.
My lord, they
advertisement.
are not disclosing, my lord.
Let's see the
The
advertisement.
department has not disclosed.
Yes. How much for written? Yes, Mr. Khan. How much for interview?
I'll have to take instructions on that also.
He's already joined.
My lord. Yes, my lord.
He's already joined.
My lord, despite
We are
No,
we,
no, my
we
lord.
can't just have a roving. Anyway, we just issue notice. If you say that you
My
get
lord.
instructions, yes. Heard MS.
my lord,
Yes.
my lord, kindly hear me, my lord. Despite the petitioner grabbing the highest mark in the written examination, the respondent number 1 has been given the appointment to respondent number 2.
One
Which,
thing
when the
people want to
petitioner
know,
is just-
how much marks totally were selected did you score and did she score? That's the only thing. Simple as that. That's why you want to do the component
we
of the
have not been
interview.
disclosed by the department, my lord. My lord, that has not been disclosed by the department. That's why, my lord, my right may be protected till then, my lord.
No, that.
My lord,
see,
in public
see,
employment,
everything is
the
subject to
recruitment-
petition. If you say that the selection was, they didn't disclose what kind of interview they were having and how many marks, and she's been selected. That the court can correct. Don't worry. Yes, heard MSS Nongsage, learned counsel for the petitioner.
My lord, my right will be protected till then, my lord.
Your rights, no one is going to
If
worry.
respondent number 2,
Yes.
my
You hear the order.
my lord,
You hear
if
the order.
respondent
Yes.
number
Let them come instructions first. Yes.
if she joins, my lord, then my right will be violated, my lord.
You already made a party. Doesn't matter. Heard MS Nongsage issue notice.
Yes, my lord, I already made her a party, but my right will be violated.
Yes, issue notice. Mr. Khan present on behalf of the respondent number 1. No other notices. No further notice necessary.
Yes.
Issue notice respondent number 2. Stop. Take down. MSS Nongsage submits that the matter concerns the selection to the post of counsellor. It has been submitted that the petitioner herein has secured the highest marks, but after the written examination, however, on the conclusion of selection process and after interview, appointments were offered to respondent number 2. They submitted that number 2 Mr. Khan to obtain instructions after 1 week. After 1 week, any appointment will be subject to the result of writ petition. Okay. Yes.
Item 7.
Highly applied, your lordship.
7.
Please, Your Lordship. Well, my learned friend has filed an application challenging the maintainability of the writ petition.
On what ground?
Lordship, a very simple ground. My one-point contention through this short affidavit is to highlight the fact that, with all due respect, this Honourable High Court is not the correct forum for this matter. If I can just take 3 minutes just to explain why. My Lord, the issue of maintainability arises from the nature of the case that has been placed before my Lord. If Lordship kindly looks at the writ petition at page 18, my Lord. Prior to that, my Lord, page 15, 15.
15. Yes.
My Lord, the petitioner's husband, late husband, was the owner of a land somewhere in Jail Road, my Lord. He was the owner of the land, and it is the case of the petitioner that the husband, the deceased husband, entered into an agreement for sale at page 18, my Lord, with me, that is respondent number 4. Page 18, my Lord, is the
1 second.
Agreement.
Number 4 is
private respondent, my Lord.
Jagmohan Prasad, okay. Right. That is page 18.
18. 18.
Yes.
This is the agreement for sale, my Lord. If Lordship looks at the next page,
Yes.
clause 1, that the full price of the property proposed to be sold as mutually and conclusively settled at rupees 1 crore 95 lakhs.
Yes.
This is where the dispute is, my Lord. This is the dispute that they are placing before my Lord, which is that, according to them, I have not paid the entire proceed, 1 crore 95. I have paid, according to them, 45 lakhs. My contention is I have paid full. Now, in any event, the husband expired, my Lord, that is at page 21. Page 21 of the writ petition. After signing of this agreement, husband expired at some point.
Yeah, 21 death certificate.
Of the husband, of petitioner's husband, my Lord.
Yes.
And subsequently, my Lord, page 22, much later, I was issued a lease agreement by the state respondents,
Yeah.
and they appear to be aggrieved by this lease agreement. So, page 25, my Lord.
Yes.
Petitioner, my Lord, submitted a representation to the Deputy Commissioner. This is on 16th January.
Yes.
If Lordship looks at page 26, the last paragraph of this representation, page 26, my Lord, last para, that being the case, it is humbly requested that an inquiry be caused on the basis of what has been stated above, the documents enclosed herewith, and it is...
possession of the plot of land now?
I have built my house already up there.
When was the lease issued?
My Lord, this was 23rd December 2021. Quite some time back. So they submitted a representation asking for cancellation, etc., of that lease agreement. Their case, again, was that I have not paid the entire amount, my lord. That application was processed. Several notices were issued by the state respondents asking for appearance. But in the middle of this, they have approached this Honorable High Court through this writ petition. The prayer, my lord, is important.
What's the prayer and the writ petition?
Yes, my lord. I was just coming to that, page 9, my lord. Page 9, my lord. Prayer 3, issue rule, so-and-so, so-and-so. Prayer 4, my lord. Issue appropriate directions directing the respondent to conduct an inquiry on the basis of representation dated 16/1/2023 and or cancel and forbear from giving effect to impugned lease agreement dated so-and-so in respect of plot number so-and-so issued in favor of respondent number 4 herein and or direct the respondent to dispose of representation dated so-and-so at the earliest and or pass, etc., etc., my lord. So there are two prayers, my lord, alternative prayers. One is that do not give effect or cancel that lease agreement in my favor. Alternative prayer is issue a direction to the state respondent for early disposal of that representation.
Seeking injunction also.
Yes, my lord. Yes, my lord. So as far as the first prayer is concerned, my lord, there is no, again with respect, my lord, there is no question of this Honorable Court, High Court exercising jurisdiction. This is for the reason, my lord, may kindly look at the short affidavit which I have filed. Now, as I had pointed out, my lord, their issue or their argument is that I have not paid the amount. And connected to that, I was not entitled to that, to issuance of that lease agreement. Now, as far as the lease agreement is concerned, my lord, lordship may kindly look at page 27 of my short affidavit.
Short affidavit, page 27?
27. No, this is annexures, my lord. Annexures.
You call it short, then I don't know.
The annexures are substantial, my lord, and that is one more point of mine.
Yes.
Page 27, my lord, is a deed of declaration executed by me prior to me being given that lease agreement, my lord. This is a deed of declaration. If lordship kindly turns the page to page 35. Page 35 is a no objection certificate where
a picture of the
petitioner and her two sons appeared before the registrar and gave the express no objection for registration of this deed of declaration. It is on the basis of this deed of declaration that the lease agreement was finally issued.
So have you filed for recall of this deed declaration also?
I'll submit, my lord. Let my learned friends.
That's point number one, my lord. Point number two about the payment part. If lordship kindly looks at page 37.
37?
Of my affidavit, my lord. 37.
Yes.
37, Annexure F in series.
Yes.
37 onwards, my lord, are the money receipts. All of which show payment in full, my lord. And if lordship even looks at page...
last but page 39 says, I'll pay 48 lakhs on a deed of registration. That was paid.
It was all paid. It's all paid. It's on. It's all paid. If lordship looks at page 51... Page 51, my lord, there are photos and there are videos and photos of the transaction of payment. Point is, my lord, why I am highlighting all this is...
Who's the gentleman counting the money in the bed?
On the bed is one of the relatives of the petitioner, the brother, I believe.
He's the right person to receive the money or you paid to someone else?
No, we didn't pay. So, point is, my lord,
How do we know, looking at pictures, who is just counting money? You know?
Exactly. My lord, point is very simple, my lord, these are all matters of evidence, my lord.
Of course.
These are all matters of evidence.
Getting at. Yes,
so,
Mr. Gautam. Why you, I mean, asking for cancellation of the lease deed after you've acceded to the deed of declaration?
So if I can just finish, my lord, I'll just take 10 more seconds. My lord, the law is very well settled, but just to arm this honourable court, if I'm allowed to place this judgment. This is from 2015, my lord. Para 69, my lord.
Para?
69, my lord.
Yes.
Para 69, the following paragraphs below that lists out the situations in which Honourable High Courts have been
Money
advised.
claims, disputed facts, these things like, see,
I don't need
even
to-
for bills or something, if only is certified.
I don't
and-
need to
and-
spend too much time on this. I'm
Yes,
confident.
Mr. Gautam.
My lord, what my
How do you seek to maintain repetition?
I have a very limited, very
least is
short,
consequential on the entire events that have
very
happened.
short argument here, my
Yes.
lord. Lordship will come to this deed of declaration. My lord, the one that my learned friend just read out, page 27 of his affidavit.
You didn't
Now-
mix it in your petition?
No, I never had it, my lord. I never had it, my lord. After my husband died, I'm an old lady who's staying in Shillong. 2 sons are studying outside. One fine day, they're asked to sign on a document saying that I'm taking care of the entire transaction. I'll help you get the property transferred. And I'm a layman. I do not know the procedure. It's not that the entire deed of declaration was shown to me or I have signed to the entire deed of declaration. My lord, it is very, very nicely only one piece of paper where no objection has been. Of course, my lord, it says that property may be transferred because we were in the terms of negotiation within the parties, within the other party, we had handed over the possession bona fidely because, my lord, there were certain tenants who the learned, who is my client said that he'll help us get rid of. That is why the entire possession of the property was given to him.
Then we can't go see,
that is not my lord. My prayer is, it is not a case where I want money, my lord.
Yes.
What I am suggesting as per law is, my lord, on the basis of a deed of declaration, I am already dead. Can my wife give NOC for the transfer of the property, my lord? Transfer of property can only happen between 2 living individuals. Section 5 of the Transfer of Property Act is
We're not
very,
going to
very
go
clear.
there. It is purely a matter of evidence, really.
My lord, lordship will just see my prayer. My lord, I've never asked for cancellation of the lease deed. I'm only asking for, I don't know why my learned friend even filed this application challenging the mental leave of the writ petition. My prayer is why the authorities have not taken a call on the representation which I have filed. That is the only limited prayer I have before this honourable court. I know very well, my lord, these are disputed
shortcut
questions
the
of
whole
fact.
process. You know that if you bang on the revenue authorities like they'll be just maybe pass some crazy order, that'll give you a handle. But after this, if you go through the correct process, it'll take you too many years.
My lord, I'm only
taking a chance before this court also.
I'm only,
and if you want to expedite everything,
I've just filed a representation before them showing everything.
When did you file it?
My lord, it was filed on 23rd. I'm sorry, my lord, 1 second. 16 January 2023.
Then?
My lord, thereafter dates were being fixed, my lord. I was only being called, nothing happened. If lordship will only give a direction to dispose of my representation rightly or wrongly.
Just get instructions. What's happened to representation?
With regards to the representation, Your Lordship, the petitioner themselves don't participate.
That is absolutely wrong.
Adjournments, Your Lordship.
One occasion the adjournment was filed, my lord. On many occasions we stood outside the door of the concerned officer, nobody was there. Unless lordship.
Now again, how do you mean this court will go and have a roving inquiry?
No, my lord.
For look at CCTV coverage when he's standing outside the door. Come on.
Well, my learned friends also filed photographs and whatnot. Well, those are different things. The only thing, my lord, here is only limited prayer, my lord.
We're going to look at the nature of the dispute. That's all. Simple.
Only thing, my lord, here
The court
is.
can adjudicate on this kind of dispute. Whether he paid the money, not paid the money, or whether
But that is not even my case, my lord. That is what he's projected. My case, I've never said anything. I only said is that, my lord, this person has fraudulently, wrongly, illegally obtained a lease deed.
Then it's a case of cheating.
My lord, that is there. But my lord, what I say is that, my lord, he has illegally obtained a lease deed which is not entitled to obtain. And I have bought the
number alternate remedy.
But only thing here is, my lord, if a direction may be just to dispose my representation, nothing at all, my lord. Rightly or wrongly, in any case.
Before them.
Well, they are not doing anything, my lord. Even in their affidavit also, they are saying that there is a deed of declaration. How can a person declare that I'm the...
That here, no.
No, well, I'm just saying, well, that is a part of my entire submission. My only prayer here is the direction to dispose my representation, nothing else. What my learned friend is projected is not the correct picture.
Innocuous. The direction may be very innocuous, but it has a lot of ramifications. We'll reject your application. We'll pass orders.
My lord.
You take your chances.
Well, of course, I do have alternative remedies, my lord. But the fact is that, my lord, the authorities are not doing anything on my representation.
Yes, who's there?
Oblige.
Who's the matter? Was it for 7-11 hearing?
Yes.
7-11 hearing, Lordships.
I think it'll take a long time. You're the one who filed 7-11.
Yes, Your Lordships. I have filed my
I think the
7-11.
court adjourns the matter. When do we want it?
I'm always here, my lord. Depends on my friend.
Your Lordships, next week. Your Lordship, next week would be fine.
Next week is okay. We listed today is the 11th.
11th.
No, 19th. Yes, fix this is matter 19 for hearing on the
9.
applicants under order 7 to 11.
Item number 9.
Grateful, Your Lordship.
Madam, this is a matter where my friend is seeking for transfer of the suit from the judge to assistant district judge to judge, district council court, which is not maintainable.
No, Your Lordship, this is not. There are two assistant judges. I'm saying that let this matter maybe transferred to any other judge equivalent. There are two assistant judges. There are one judge of the district council court, two assistant judges. My learned senior friend, I think, is misunderstood.
No, Mr. So there's a missed civil appeal that's pending for the additional judge, correct?
Lordship.
As per what you've written here, if I correctly remember from last time. And then the main title suit's proceeding before the trial court assistant judge, correct? You want to stop the trial suit also, the trial court, and send all the matters to the additional judge?
Lordship, the here is like this. First, additional judge, he has attached my property in the first instance. In the title
so he is
suit.
biased.
Then after that, that order was stayed. Against that order, at the time when the case was there, the judge of the district council court, that retired, and there was nobody. Then at that time, since that earlier order which the property has been attached, against my property has been attached, I filed in against that order, and that order has been stayed by the judge of the district council. And again, the same judge, he has passed an order again attaching my property. So against that order I have come. This order has stayed that order, saying that that is illegal. That order I have. Now I have come here that because the same judge, again, he's taking up the main suit.
You don't want a judge to take your case anymore?
I want let this matter maybe come to some other judge. There are two judges, two assistant judges.
I understand.
Two
I understand.
assistant
you feel
judges.
that in this court you won't get any more justice.
Because
Yes,
that is
that is not the bleeding of my friend.
Not a but that's
it is on record. It is on record. It is on record.
That is not the bleeding. First, my lord, Lordship kindly see page number 10. Just a little Bible.
Yes.
Because it will have an impact on the trial court. That's why I just want to clarify. And page number 10, my lord. The miss case number 8, 2013.
Where? Wait, which paragraph are you reading?
My lord. On the top, my lord.
The miss case.
Annexure 1.
Yes.
My lord, this is the first attachment order passed by the assistant judge. Here they mentioned it as a magistrate first class. So this order was assailed, and my lord, we come to page number 13. That order was stayed by the judge district council.
And this is pending now.
And this is pending. Now, after passing this stay order, the judge retired.
Okay.
And thereafter, my lord, page number 15. Similar order of attachment order was passed by the assistant judge again, the same judge.
Similar again, yes.
My lord, 1/7/2012. Against this, my lord, my friend has challenged before this honorable court, and this honorable court has set it aside. And
Yes.
page number, my lord, 22.
Because there was no judge that time.
My lord, that time, the judge was not there.
Yes.
Additional judge was there.
Right.
My lord. And lordship, kindly see the order, page number 23.
Yes.
Para 4. Hello.
Yes.
In view of the submission of the Legislative Council for the sole respondent, the impugned order is caused and set aside. Accordingly, Ms. Appeal person is to process before the concerned court in accordance with law. However, yet it is informed that the court of the assistant judge, my lord, it is in fact the judge, is being judged, my lord. District Council Court Tura is not functioning. It is expected that the matter is taken up by the competent court, that is additional judge.
Now this appeal is pending for the additional judge.
My lord.
Now the main suit's pending for the assistant judge.
Now, yes, main suit is pending before the assistant
I understand. He doesn't want that main suit to proceed assistant judge. He wants even the main suit to transfer to additional judge.
That is why that is not permissible.
That's not permissible.
That is not permissible.
That is what the court has said.
My lord, exactly.
Just because you and they believe that once the Mrs. Appeal had gone to additional judge, that the whole suit will have been stayed. No, so you file for stay of the suit.
Lordship,
and my Lord, kindly see page number 25.
May I just
is
admit,
the
maybe
last point.
there may be some defect in my pleading, but the fact remained because the title suit, this same judge, he has attached twice.
File for stay of proceedings before the court of additional judge itself. If you feel that the outcome of the Mrs. Appeal will affect the suit, you file a correct application. Then the additional judge will examine it to stay for the proceedings. This court can't pass an order that that a misappeal, civil appeal is misappeal is pending before the additional judge and the suit's pending for assistant judge, that the additional judge will take up everything. No,
this cannot be done.
Yes, only contention is Lordship has correctly understood because this judge has two.
Your only grievance is that you twice. One order you got a state, then the judge retired. Then second time similar orders passed against you. You came before this court, and then because it should be a civil appeal, it was sent to the additional judge that they'll take up the appeal against that order. Correct. Yes. Now you're saying that the assistant judge is proceeding with your suit. You want to stop that. That's the only thing you want. Correct.
Stop means like maybe some other judge, same judge, but then there are two assistant judges.
That will have a serious impact on the learned judges.
Alleging bias.
Bias, man. There is no allegation of biasness. Others, my Lord. That is why, man. Let them
understand. No, sometimes lawyers have this. You have to understand them also. In that context, we feel that in spite of we got one order of stay, again second order, then we had to come to this court. Then this court said, okay, fine, they had set the order and the misappeal to be heard by the additional judge. So again, the suit proceeding. Right. So that's the thing.
Twice the order is stay. One by the judge of the district court, one another from the district court.
Since the additional judge is not there today, judge is there now. As far as information is concerned.
No, judge is there well and good.
Judge can take up the case number 2.
That's a Mrs. Appeal only.
Yeah, misappeal only.
The suit is still pending with the assistant judge. The suit is the main thing.
The suit is the main thing now. The suit should proceed, my Lord.
Of course.
The suit should proceed now.
No, he wanted to go to another assistant judge. He said that let the additional judge take up the suit also. I don't know.
That is not permissible, my Lord.
We take instructions.
Lordship.
After 1 week. Yes.
Lordship, yes.
This matter 1 week enable the council petition to obtain proper instructions.
Number 10?
Yes.
10?
Otherwise, yes.
Well, this is a contempt petition.
Compliance.
We had given last 1 week chance.
Lordship, Learned DSJ is appearing.
Yes, Dr. Mozika complied.
My Lord, I have written to them, my Lord, the instructions have not come.
No question of then who's there? Then the Lieutenant General has to appear in person.
The second round of litigation, in fact, my Lord, the first writ petition was filed in 2018.
That certificate from Lunglei or something.
Well, we already submitted everything. Whatever they've asked for, my Lord, we have submitted everything.
Who's the concerned person who has to appear then?
But actually, what happened, my Lord, certain other documents were required.
No, this is
which they have submitted.
It's supposed to come instructions today.
We already submitted everything, whatever they've asked for. Lieutenant General Pradeep Chandran Nair.
Yes.
But even this matter can come tomorrow, my Lord. I'll try to get some instruction to them.
Tomorrow. Otherwise, sorry, Lieutenant General have to appear. Yes.
Hello.
Obliged.
11.
Difficult.
I don't know. Hearing like
This case is no 1 and 2 as file affidavit, Lordship. Only not pending.
Number
that
3?
is
Number 3, Lordship, still
not yet.
Still awaiting your Lordship the service.
Office to indicate that this ceremonies are complete list after 1 week. Petitioners are at liberty to obtain status of service as number 3.
12.
This is
connected here.
13. 13.
Yes, Mr. Tar.
I am reconstructing the file, Your Lordship.
Still?
May be given time.
Okay, Mr. Please for the loud. How much time reconstruct the file?
2 weeks.
2 weeks time reconstruct the file. List thereafter. You lost all the records, that means.
All.
14.
Please, my lord. My lord, the respondents are yet to file their affidavits.
After 2 weeks, I'll file an affidavit.
Why?
This got an instruction.
This was filed on last year.
Last year. This is the 5th.
Which department?
This is the Deputy Commissioner's Office, the amalgamated establishment.
For the 2 weeks' time, as period granted to respond to an affidavit.
15.
Similar matter. 15, 16.
16.
Your Lordship, our prayer in this writ petition is very limited. We just seek the direction of this.
Rejoinder? Now what's
I
happened?
have already filed the rejoinder, Your Lordship.
Okay, what's your...
Yeah, the rejoinder,
it's
Your
for hearing?
Lordship. No, Your Lordship,
Oh,
it's
yeah.
for order.
Why you dispose of today?
If
Why? What's your limited prayer?
Your Lordship, prayer is that before implementation of the JJM project, Your Lordship, we should be allowed to perform the prayer because that has been done in the...
But is not objecting to you holding the prayer?
Yes, Your Lordship, but they have attached a certificate, no objection certificate, Your Lordship. It has nothing to do with the writ petitioners, Your Lordship. This is the no objection certificate issued by the lingdo of the Raj. The lingdo, but this particular lingdo here, he does not perform any religious function.
Which NOC? Where's that?
Your Lordship, it is annexure 1, page 7 of the counter affidavit.
Translated copy is in page 8, Your Lordship.
So,
And this particular objection also, Your Lordship, is only with regard to one village. But here we are, in our writ petition, we are saying that a number of villages are going to be, the water supply scheme will be implemented from this particular religious side of the petitioners.
it will affect the religious side of the petitioners?
Yes, Your Lordship,
Then
because...
it requires a hearing.
Your Lordship, here we're saying that we're not denying the
No, it
right
requires a
to...
hearing. We'll hear. 2 days, a bit short of time.
All right,
Okay, Your Lordship.
Up to 1 week, yes.
Highly obliged, Your Lordship.
17.
Item 17 and item 40, my lord. Both are connected matters. It requires some hearing, my lord.
17
and 40.
17 and 40.
Finish your part.
Yes, Mr. Singh has
Supposed-
finished his concluded argument.
Advocate General is supposed to reply.
Too many partners because of my other obligations. Very difficult.
Tomorrow.
Yes?
Tomorrow, Your Lordship?
Tomorrow is. Tomorrow also. Anyway. We hold external affairs of the High Court affair, what to do. Have to go for meetings. Yes.
22.
It's tomorrow. Yes.
Hearing 22.
That's here, Mr. Thomas. You can finish in 1 hour?
15 minutes, sir.
Oh, very good.
I will try to finish within 15 minutes.
You already given your compilation, correct?
I have given compilation and a brief written synopsis of arguments also. My undersigned has replied. So I am in a
What
rejoinder.
argument you want to make?
Pardon, Lordship?
You want to make rejoinder argument?
Rejoinder argument.
Yes.
In this case, actually there is no dispute between the parties on facts. Facts everybody accepts. So, this is a very simple case where an arbitral tribunal was constituted for some disputes.
Yes.
The one and only dispute was there was some final bill items or small items. A very interesting submission I am making. See, the situation in our country before the amendment of the Act, the issue was, main issue was,
whether the rate should be applied for 100, more than 100 or more than 125. That was the only dispute. 17 years were taken to decide that dispute. And when it decided also, half this way, half the other way. It did not say either 20, 100 or 2. 17 years. But because at that time there was no time limit. That was maybe what some of the reasons that now the Parliament has fixed time. You have to come within so and so time, 1 year. Otherwise, it can be done. So now we are comfortable now. So this is the only main dispute where 17 years were drawn. But ultimately, as a party, I am helpless. As a party, the petitioner is helpless. We are going there, and then this is going on. Whatever it is. Now the matter is over. Many of them are no more. So that I don't want to comment on anything on that. Now, when the award was made, both parties challenged the award. I said it should not have been halfway. I should get the full. Their main argument was that they have filed a petition under application under section 16 of the Act, saying that these disputes cannot be arbitrated, something like that. The arbitrators held questions of facts are involved. Therefore, we will decide it later along with the final award. That there are cases where it can be done like that also. But after 17 years, when the award was made, they must have forgotten to consider this, but the award was made without dealing with this dispute. So they took an objection before the district judge that this award cannot be hold good because this application was not decided. When I framed the reply, I could not make this objection for the reason that if that application need not be decided, then section 16 become odious. So there was no case law which says that if section 16 is not decided, then also award can be made. There is no such law, no such judgment, no such precedent. So I could not make that argument. Therefore, when the section 34, both were filed, when the respondent's petition was taken up, I made a submission that this objection I could not meet because I could not see any legal provision or judgment which said that, okay, without deciding this application also, this award can be made. So I am finding it helpless. So judge then heard both the parties, and then their objection was recorded. This is your objection, and I am not able to meet that objection. Therefore, for this technical reason, I am not looking into any of the claims awarded, because I cannot proceed now. Therefore, I set aside the award. And parties has liberty to do whatever they want. But if they take any action, 33(4) will help them. Because this time will be. It's not that the Honorable Judge said that, okay, you should get under 33(4). They say, if you go under the Act, if you proceed, then this 33(4) will also help you. This is the only thing. Now what happened? I therefore issued a notice to them that I want to start arbitration. And I also made a request that there were 17 years, 3 arbitrators were holding this hearing. Let us refer to a common single sole arbitrator so that expense can also be reduced. They have their own position. They said, we don't want to dilute the agreement. Agreement is for 3 arbitrators, so that we will not do. But you can do one thing. You can go for conciliation. We are ready for conciliate with you. I said, well, conciliation is possible. So then they called us, and they said, out of these disputes, the main dispute is this 100.
How many claims?
Actually, totally 7 claims, including interest.
Okay.
And the main dispute was about final bill and some security. So that was also this, for 22 years they did not pay. They said, this we will settle amicably between us. We said, agree. They offered some amount. I agreed to that amount. Because after these 22 years, where I go. But then whether I should get interest or not, they said that can be referred for the conciliate. So they said, let's just give this to a conciliation committee formed by the government. I said, okay, we will go there. In the conciliation committee, when they proceeded, after 2 set of hearings, Consideration Committee said, now you frame what are the requirements that we should decide. They said, we will not agree, because they have gone back from the assurance that this will be given to Conciliation Committee. They said, no, we will not accept conciliation for this because it is contrary to contract. So then again I issued a notice to them, saying that, okay, now you are withdrawing from the conciliation, therefore I want to. So therefore, even in their mind, it is decided that this matter is not decided and yet to be decided. That was their position also. But there's a conciliation. My learned friend during argument was suggesting that conciliation, okay. If conciliation failed, you have no remedy for arbitration. You have to go for a civil suit. So that is not the position. When there is an arbitration agreement, it should be go for arbitration. This is the position. Now I deal with, there are only 2 objections they have taken.
Yes.
Number 1, they say, the learned district judge dismissed the objection on merits. Once learned district judge dismissed the objection on merits, res judicata will apply and you have no remedy at all.
Yes, that's important.
That is the important submission they have made. That is number 1. Number 2, the second objection they are making is that once a dispute is referred and an award is made, there cannot be a second reference.
Yes.
These are the 2 objections. Everything else is coming from these 2 objections only.
Yes.
So I have to meet these 2 arguments. Now, in fact, it is all coming from the common position. But first, your Lordship may kindly see whether the district judge dismissed the objections on merits.
Yes.
The first issue is, what is decision on merits? Merits means the 7 disputes which were decided by the arbiter tribunal was decided this way or that way by the district judge. Otherwise, there is not on merits. Otherwise, on a technical on grounds, it is dismissed. Now the judge, so kindly see that judgment, which is page 33 of my petition.
Yes. Middle part, paragraph 13.
I am reading paragraph 12, 13 and 17.
Okay.
So, paragraph 12, what may kindly see? Page 33. What? Paragraph 12. The challenge to the award by the applicant is on the one ground discussed above, which finds in place in ground G, that is the respondent's objections of the application. In order to comprehend the grounds of the challenge, ground G is reproduced. This is their ground. For that, the issue relating to maintainability, limitation, non-compliance of the prerequisite of the arbitration clause of the contract agreement were raised by the applicant corporation in its application dated 16/5/2005, filed under Section 16 of the Arbitration Act 1996. The respondent filed response to the said application, and the applicant also filed a rejoinder to the said application, which was heard at length. The Arbitration Tribunal, by its recent order dated 29/5/2008, held that the preliminary objection raised on behalf of the applicant in the said application, can you see the preliminary objection? Raised on behalf of the applicant in the said application cannot be adjudicated at this stage, as the evidence is yet to be led by the parties, and accordingly, the preliminary issues raised in the application were left open to be decided at the time of passing of the final award. Kindly mark. The evidence, both oral and documentary, were led by both the parties on the preliminary issues raised by the applicant in its application dated 16/5/2005, and the oral arguments were heard and written synopsis on the preliminary issues raised by the applicant in the application under Section 16 were also filed. But however, the Learned Arbitration Tribunal in the final impugned award dated 18/1/2020 failed to decide the said application dated 16/5/2005 filed by the applicant under Section 16 of the Arbitration Constitution 1996. Hence, there is a gross error apparent on the face of the record, and the same goes to the root of the matter, and the impugned award is vitiated by patent illegality appearing on the face of the award, and in view thereof, the impugned award is to be set aside on the ground of public policy under so and so, so and so, so and so. This is their objection. Now, the learned judge is considering that. On perusal of the reply filed by the respondent, this court finds that there is that there is no substantive rebuttal of the ground G referred above. See, I could not rebut that ground. Further, on close reading of the impugned award, this court finds that the tribunal has not returned any finding on issue number 2 and number 3. This court, without referring to any decision, to fortify its conclusion, finds that the impugned award suffers from violation of the principles of natural justice. Naturally, that application was not decided. The applicant has been deprived of the opportunity of being heard. As such, he has not given fair opportunity to present his case. The impugned award dated 18/1/2020 was passed in breach of Section 18 of the Act, 1996. As such, that is only for that they are not able to be heard. They could not be heard properly. As such, it suffers from the infirmity under subsection 2(3)(2)(a) of Section 34 of the Act 1996 and liable to be quashed for that ground. This court at the recital had mentioned that the respondent has not resisted or defended the legality of the impugned award on the above mentioned ground. I could not meet. Rarely the court announced such a fair concession made so and so, so and so. Now kindly come to 17, page 17.
Page?
Page 35, para 17.
Okay.
I can read the others also, but the concession is this one. The learned counsel for the respondent prays before this court that the respondent may be given liberty to take appropriate action in accordance with law and has placed some authorities before this court to substantiate his argument. This court finds that the respondent is entitled to equitable relief for his assistance rendered to this court. The prayer of the respondent does not run contrary to the contract, nor there is any statutory bar. The respondent is at liberty to take appropriate action in accordance with law. Needless to say, the benefit of Section 43 of the Arbitration Act will be available to the respondent in the event of the respondent seeks remedy under law. That is not that the court is directing me to do something. In the event I take some action, then that Section 43 will assist me in getting bar the limitation. This is what the court has done. Where is the question of deciding the disputes on merits? On this preliminary issue that was decided. Therefore, it was not, on merits means not on technical grounds. This is on a purely technical ground that was decided, and we did not go into any of the claims or taken up argument for any of the claims that was done. So now I also show their affidavit in opposition, para 5. Their affidavit in opposition in page 5, para 5.
Yes.
Good. Para 5 in the bottom, Lordship.
Yes.
That both the parties' petitions were heard at length and the commercial court wide judgment order dated so on, set aside the award dated so on, so on its merits. On its merits. That's only I have objection. As agreed by the parties, the disputes claims are also referred to the committee for conciliator. That means, after the setting aside, they themselves know that it should be again re-agitated of independent experts. But since no final agreement for settlement of the claims could be arrived between the parties, the conciliation proceedings were dropped. So they themselves say, these disputes which are part of the first reference were never decided. That is why they say, let us go to so. They themselves admit it is not yet decided. Therefore, there is no question of deciding the disputes on merit has taken place. That's number one. Number two, now I will submit that in such situations, how the courts had considered this matter. I am deciding, repenting only on those judgments which I have submitted before the court. And my learned friend could not meet any of those judgments during his arguments. Now kindly come to the first judgment, that's the Supreme Court judgment. That is...
DLF form.
No, that is only for arbitrability. That I will come later. Yes. Because that law was settled by Lordship also under Section 8 petition. That I want. Now, I come to the serial number 3.
Jagilal Kamlapat.
Because I am only, that is, Jugal Kamalpat, I am obliged. That is, I am only referring to 2 paras. That is in page number 42. Page number 42.
Yes.
This I am, for saving time, I am dealing with 2 arguments. Second argument is that in the arbitration clause, if there is no provision for a second reference, then you cannot have second reference also. Therefore, to meet the argument, kindly come to that arbitration clause in this case, that is in the beginning. That is in page 42. All matters and got it?
Yes, all matters.
So that is a normal arbitration clause. Lordship has posed a question: is there in any arbitration clause which will say that the second reference should be allowed?
Yes.
That is not there. Every case is that. In this case also, Supreme Court judgment. This is the arbitration clause. Now kindly come to this paragraphs. I am only referring para 10 and 15. Para 10 and 15. First, Lordship may kindly come to that is in page number 47. I will first read para 15 so that we will get the picture. Para 47, page 47, para 15. Then we will come to para 10. What happens in this case is, Lordship got it?
Yes.
What happens in this case is that the previous tribunal made an award. That is in our case, that's some case. That award has been set aside on account of misconduct. So, award can be set on various grounds. In our case, it also amounts to misconduct for not deciding Section 16, but this misconduct is not a ground under the new Act. In the old Act, misconduct was a ground. Here also, it amounts to misconduct for not deciding, but whatever it is not decided. The award has been made on account of misconduct. In the circumstances, we are of the opinion that the previous tribunal has become incapable of acting as arbitrator to decide those disputes because of this misconduct. In our case, because of not deciding Section 16. Further, as the reference has not been superseded and the arbitration agreement subsists, it was, in our opinion, open to the chamber, that is the Chamber of Commerce, on the request of the respondent to appoint another arbitral tribunal under RX. Therefore, as there is a machinery by which the fresh arbitrations can be appointed according to the terms of the arbitration agreement, read with the rules of Chamber of Commerce, and the reference has not been superseded, that the appointment of the fresh arbitral tribunal and carrying on the arbitration process further were within the terms of the arbitration agreement. I have first shown the arbitration agreement. So therefore, when there is an arbitration agreement, there need not be any provision that you have a second, etc., etc. Now I will read this from para 8 onwards. That is, kindly come to page 44, para 8. Before starting, may I submit one difference?
Yes.
This was made under the old Act, 1940 Act. In 1940 Act, there is an express provision, Section 19, which says that when an award is set aside, court has got a power to supersede the arbitration also. Supersede. Arbitration is superseded by then you cannot have a second arbitration. If it is not superseded, it is automatic that you can
go second
arbitration. But in the new Act, it is not there. Instead of that, we have got Section 16, that a party wants to have this arbitration going, the other party go under Section 16 and go say, the tribunal cannot proceed for such and for the jurisdictional objections. So, to explain that, may I read para 8 also?
Yes.
It is clear from Section 19 that there are 3 matters which have to be borne in mind in arbitration. It's very important for my submission.
Yes.
3 matters. Supreme Court judgment. There is first the arbitration agreement. Yes, in our case of the agreement. Next comes the reference to arbitration, and lastly the award. So three things in an arbitration agreement. First, there is an arbitration agreement. Then there is a reference. In our case also, there is a reference of 7 disputes. Arbitration agreement, 7 disputes, and there is an award. Section 19 provides inter alia that where an award has been set aside, the court may by order supersede the reference and shall thereupon order that the arbitration agreement shall cease to have effect with respect to the difference referred. The section therefore leaves it to the discretion of the court when it decides to set aside an award whether to supersede the reference or not. It may not supersede the reference at all, in which case, though the award may be set aside, the reference will continue. Kindly mark here, Lord. But if it is supersedes, the reference it has also in consequence to the order that the arbitration agreement on the basis of which the reference was made would cease to have effect with the respect to the reference referred. It is only therefore when the court orders supersession of the reference that the consequence follows that the arbitration agreement ceases to have effect with respect to the subject matter of the reference. The intention of the legislature in making this change in the consequence to follow the setting aside of an award is clear in as much as the provision recognizes that there may be different kinds of arbitration agreements, some of which might be exhausted by the reference already made and the award following their own, which has been set aside, while the others may be of a more comprehensive nature and may contemplate continuation of the reference relating to the same dispute or successive references relating to the different disputes covered by the arbitration agreement. We have seen in the beginnings, Lordship, that this also has as arbitration agreement, common arbitration agreement. The legislature has therefore given discretion to the court under section 19 to decide when it sets aside an award what the consequence of this order setting aside the award will be. If the court finds that the arbitration agreement is of kind which exhausts itself after the first reference is made, or if it finds on account of reasons which has impelled it to set aside the award that there should be no further reference of the dispute to arbitration, the court has the power to supersede the reference and thereupon order that the arbitration agreement shall cease to have effect with respect to the referred. On the other hand, if the court finds that the arbitration agreement is of general nature, in our case general nature, and contemplates continuation of the reference with respect to the same dispute or successive references with respect to different disputes arising under the terms of the arbitration agreement, it may not supersede the reference, with the result that the reference as well as the arbitration agreement on which it is based survives. In such a case, there can, in our opinion, be no doubt that where the reference and the arbitration agreement survives, the same dispute may go before arbitrators, again, provided there is a machinery provided in the arbitration agreement which makes this possible. It will thus be seen that the discretion vested in the court under section 19 depends upon the nature of the arbitration agreement in particular cases and on a consideration of those terms that the court may decide in one case to supersede the reference and order the arbitration agreement to cease to have effect after taking into account the reasons which have impelled it to set aside the award, and in another not to set aside the reference, with the result that the reference and the arbitration agreement subsists, and if the arbitration agreement provides for machinery to have further arbitration on the same dispute or the other disputes arising under the arbitration agreement, it is impermissible to have further arbitration on the same dispute or the other disputes. I am posing for here. So now we have also have the same arbitration agreement, Lordship. Now kindly come to para number 10. In page 46, Lordship. It is not in dispute that the reference was not superseded in this case when the award was set aside in May 1953. So in our case also, award was set aside. It will therefore depend upon the terms of the arbitration agreement in this case whether it was possible to have further arbitration with respect to the same dispute. So our arbitration agreement is also here, same. We have already set out the terms in the contract relating to arbitration, and it is clear that the term is very wide. Kindly, our term is also very wide. in its amplitude, and the contemplates reference of disputes as and when they arise between the parties to the chamber. Further, as the chamber is constituted, the arbitrator in this and the chamber consists of a large number of members, and it has so on, so on, so on. Now, kindly come to after 4 5 lines. It is, however, urged that is also, this is the objection the other side has taken. Yes. It is, however, urged. You got that line? Lordship got that line?
Oh, that is the second reference of same.
Yeah, right. It is, however, urged that this is a second reference of the same dispute. This is, they are banging on this. This is a second reference. It's not a second reference. That this is a second reference of the same dispute, and this is at any rate is not contemplated by the terms relating to arbitration in the contract. This was the same objection the other side. We are not impressed by this argument. Stress in this connection was being laid on the letter dated of the 7th in which the respondent, that means the petition hearing, said that it begged to refer the matter for arbitration de novo. In that case, when they have written a word de novo. So, picking on that sentence, word, the other side argued, when they asked for de novo reference, that means it's a second reference. Court said, by using that word, you cannot make it a second reference because the same reference continues, same dispute is not decided. Those words do not, in our opinion, show that a second reference was being made of the dispute. I am posting there here. The letter being by saying that the chamber was aware of that the previous award has been set aside, it was in those circumstances that the respondent told the chamber that it begged to refer the matter for arbitration de novo. In the context, this can also mean that the respondent was asking the chamber to take up the reference again, as the reference had not been superseded and arranged to continue the arbitration proceedings further. We are also in the same position. The only question, therefore, that will arise is whether, under the rules of chamber, it was possible to continue another tribunal to consider this dispute again. If that is possible, we fail to see why the arbitration proceedings should not go on further, as the reference was not superseded in this case and the arbitration agreement subsisted. So, this arbitration clause was also here, and it said that there is no such that second reference or anything. And another point which the Supreme Court has held is that there is no second reference. Arbitration agreement, reference and award. Now here is arbitration agreement is there, a reference still continues, that disputes are not decided. And third, that there should be an award, and award was made but it was set aside. So this is a Supreme Court judgment. Then I refer to one or two judgments. That is 1958 Calcutta, which is referred in the Supreme Court judgment. That is in page 49. This judgment also referred in Supreme Court judgment. I am reading para 14.
Page 49?
I'm sorry. That is Calcutta. Page 49 starting, I am reading para 14. Only limited paragraphs I am reading 14. Page 50, page 54, Lordship. Page 54.
Compilation.
Compilation 54 and para 14. But I'm sorry, Lordship, also may kindly, in the same page, the other side, Lordship may kindly mark after third line, but where the reference? In page 54, in the first column, third line, after in the fourth line, but, you got it, but?
But where there was no...
Yes, I'm kindly one. But where the reference was valid, in our case, the reference was valid, and only the award was bad. The mere setting aside of the award would not affect the reference. So, my learned friend says second reference. This will not affect the reference. In such a case, the reference and the agreement stand or fall together. If the court makes a further order superseding the reference, it must direct that the agreement as well as cease to have effect so that both comes to an end. So, arbitration agreement is one thing, reference is another thing. The combined effect of the two orders which must always be jointly made, is that the provision for arbitration is superseded altogether, and it is because of such effect that Section 25 of the Act describes that order under section as an order superseding the arbitration. Where, however, the court does not supersede the reference, both the reference and the agreement continue to subsist. There can be no question in such a case of either the reference coming to an end or the arbitration agreement having been exhausted by the reference already made. This is I am dealing the argument of second reference. Now kindly come to para 14. The same page. Para 14.
Yes.
If the original reference made to the chamber remained subsisting even after the first award has been set aside, in our position, it is plainly impossible that there could be a second reference. Kindly mark. This gives the distinction between first reference and second reference. Page 54, that's reference to the chamber of This would follow from both from the general law and the terms of the arbitration agreement. A party to an arbitration agreement can no more run two parallel references before the same arbitrator on the same dispute than a plaintiff can run two parallel suits before the same court on the same cause of action. Giving the analogy. Nor did the arbitration agreement provide that a party to it could make a reference to the dispute, abandon it when it was still pending, and then make another. So this is all giving the logic of not a second reference. I therefore agree with Bajawat J that if the communication date addressed to appellant to the chamber and so has to be treated as a second reference, it must be held to have been incompetent. It's not a second reference. I do not, however, take that the view on the ground that the obligations to refer the agreement was fully carried out when the original reference was made, and that after the award made on that reference had been set aside, there was no scope for any further reference. That ground being by the judge presupposes that the original reference had come to an end with the first award, which I do not consider to be correct for the reasons I have already given. But I agree with the learned judge's conclusion on the ground that on 30th November 1953, that is on the first award of the original reference was still subsisting, and therefore no second reference on the same dues could have been made. Now the last paragraph, I am only sorry. That is page 60, Lordship. Page 60, para 33. Para 33, Lordship.
Yes.
Para 33. This judgment has run to a considerable length because of the large variety of matters discussed in the judgment under appeal. But in reality, the question involved in the case is a fairly simple one. When the first award was set aside, the reference has not superseded. The reference therefore remained subsisting before the Bengal Chamber of Commerce and the industry even after the award made by the first arbitrator has been set aside, and it was that reference which was resumed and continued on the second application made by the appellant. Exactly my case. This is my case. So now kindly, next judgment is 1994 Calcutta, Lordship. That is page 62. Kindly see page 63 in the first para. The arbitration clause was very brief. You got it? 6. Any dispute arising out of the above understanding or due non-implementation of the above understanding by other side or the same so on so will be referred for arbitration. So very, very brief arbitration clause. Very brief, 3 lines. Thereafter, disputes and differences had arisen between the parties, and the petitioner by letter dated so and so appointed an arbitrator. The respondent, Mr. S.P. Sinha, however, did not send his concurrence to the said appointment. Thereafter, the said arbitrator proceeded with the reference and made an award. The said award was set aside by an unreported judgment and order passed by Justice Ruma Paul, dated so and so. This is to be noted that the said previous reference had arisen in respect of the same disputes between the same parties and was made under the same arbitration agreement as the instant case before me. Now kindly come to para 9, Lordship, in the next page. Page 64. Page 64, para 9.
Yes.
This is also their objection. This is also dealing with their objection, Lordship. Para 9. It was inter alia submitted on behalf of the respondent that there could not be a second reference on the same subject matter since there has already been one reference earlier. Exactly the same argument. Now take it. The said point is, in my opinion, of no substance in as much as, so far as the first reference is concerned, it was held by this court that even appointment of an arbitrator was invalid and no reference could have been held by the arbitrator. The said award made by the earlier arbitrator was set aside on the ground of lack of jurisdiction. So, various methods. One is lack of jurisdiction, one may be misconduct, one may be you have to decide under section 16. The effect, therefore, is that there was no reference at all and the said purported reference was honest and of no legal significance in the eye of law. The learned counsel for the petitioner relied on the division bench judgment of the AR 58 Calcutta. This is the same judgment I read just now. They are referring to this judgment. So and so, in the said case, the division bench held that if there is no order of supersession under section 19 of the Arbitration Act, the reference and the agreement both survived. Both will survive. The division bench also held that the setting aside of the award does not by itself terminate the reference, except obviously where the award is set aside on a finding that the reference itself was invalid. In my case, a reference is valid. It was also held that when the award was set aside and there was no order of supersession, there could be no question of either reference coming to an end or the arbitration agreement having been exhausted by reference already made. In the instant case also, there was no order directing that the agreement of arbitration shall be ceased to have effect. The division bench also held that if the agreement is wide enough to cover all disputes, that can obviously be successive references under its authority. In the instant case, the appointment of the arbitrator on the earlier occasion was held as invalid, and it was also held that the arbitrator has no jurisdiction to arbitrate. Under the circumstances, the dispute remained undecided, and since the arbitration agreement survives, the same is enforceable and fresh reference can always be made on the same dispute. Now kindly, I am not two judgments under the new Act. That is, Supreme Court, one judgment is only brief, page number 94, Lordship. Page number 94. McDermott International. Lordship, para number 51, Lordship, in page 94. McDermott International, that I am reading para, only two paragraphs.
Page?
Page 94. 94.
51, 52.
Lordship?
Para 51, 52.
Para 51, 52. Para 51, 52. This is, whatever I already read is under the old Act, but the principles are the same. Because when a reference is made and that was not culminated in a uphold awarded, then it is of no use. 51. After the 1996 Act come into force, under section 16 of the Act, the party questioning the jurisdiction of the arbitrator has an obligation to raise the third question before the arbitrator. Such a question of jurisdiction could be raised if it is beyond the scope of his authority. It was required to be raised during arbitration proceedings or soon after initiation thereof. The jurisdictional question is required to be determined as a preliminary ground. A decision taken thereupon by the arbitrator would be subject matter of the challenge under section 34 of the Act. In the event the arbitrator opined that he had no jurisdiction in relation thereto, an appeal thereof was provided under section 34 of the Act. The 1996 Act makes provision for the supervisory role of the courts for the review of the arbitral award only to ensure fairness. The intervention of the court is envisaged in few circumstances only, like in the case of fraud or bias or the arbitrator, violation of natural justice. In our case, the violation of natural justice, that is what the court has held. The court cannot correct errors of the arbitrators. it can only quash the award, leaving the parties free to begin arbitration again if it is so desired. So, New Act also says if it is set aside, if I desire, I can start the arbitration. So, the scheme of the provision of this scheme is keeping a supervised role of the court a minimum level, and this can be justified. So, if an award is set aside, the McNabad judgment says, Supreme Court says, you start another arbitration because the disputes are not determined.
Not resolved.
Not resolved. Now another interesting judgment, 2008 Guwahati, that is page 126. Page 125, Lordship. It is in para 2, and after 6 lines, 2, 4, 6 lines, it starts on 17/6/1996. Lordship got it? 17/6/1996.
The middle part.
In the bottom.
On 7 cents, petition sought for appointment.
On 7 the petition sought for appointment of the arbitrator. Yes, Lordship. Yes. For settlement of dispute which arose during the execution of the above mentioned contract. The dispute was duly referred to the arbitrator by all the parties. The arbitrator published their award and so on, so 21. Now kindly come to next page. The agreed award, the petitioner approached the competent civil court under section 34 of the Arbitration Conciliation 1996, challenging the award. The arbitration award was set aside by the additional district judge, so and so, Guwahati, by the judgment dated so and so. Similar to our case, set aside. Subsequently, the petitioner called upon the respondent by his notice dated so and so, seeking reference of the dispute for arbitration again. The same case I have also done. I have also asked for done. Admittedly, that notice was received by the respondent so and so, but the respondent took no action on the notice, hence the present petition. Exactly in my position. The respondent has been served and it is represented by so and so, so and so, and so and so. The learned counsel for the petitioner submitted that the arbitration agreement subsists until the dispute is finally resolved. That's my case. And in view of the fact that the award given by the arbitrator earlier is set aside by the competent civil court, the dispute still subsists and is required to be resolved as agreed between the parties by arbitrator. Exactly my position, my case. On the other hand, the learned counsel for the respondent submitted that the parties having availed the arbitration proceedings once cannot resort to agreement repeatedly, and therefore the petition is not entitled to any relief under the present position. Exact position what they are taking. The learned counsel made a submission that arbitration proceedings having been availed once by the parties to the agreement, the authority stood extinguished and the agreement does not authorize a repeated resort to arbitration agreement. Exactly what they are arguing, Lordship. Now, kindly come to para 10. As already noticed, both parties agreed to have a dispute, if any, resolved through the process of arbitration. Admittedly, during the course of execution of the work, contract dated so and so, certain disputes arose between the parties, details of which are not necessary for the present purpose. Both the parties referred the dispute for arbitration and the arbitration passed an award which could not be sustained in do and has to be set aside by the civil court. Exactly same position. In the result, there is no resolution of the dispute between the parties. In my case also, there is no resolution between the parties. The award which is set aside by the competent court is non-est. On other words, there is no award in the eye of law. The object of the purpose of the Arbitration Conciliation 1996 is to provide for a mechanism for settlement of dispute between the parties, and parties agreed to have dispute resolved by way of arbitration. Therefore, in our view, until the dispute is resolved, the arbitration agreement subsists and the authority to refer the dispute to the arbitration is not exhausted until the dispute is resolved. Exactly the same position, Lordship. We therefore reject the submission made by the learned counsel for the respondent. Now, para 11. Lordship. It's very interesting. They are giving a logic on for this. Given under the scheme of the arbitration, the Constitution 1996, under section 12, the appointment of an arbitrator can be challenged on any of the grounds indicated under section 3 when the requirement of subsection 3 were unsatisfied. The appointed arbitrator cannot continue to be, if he fails within the clutches of any of the disqualifications intended in the section 12. In such a situation, to hold that a fresh arbitrator, in that case, arbitrator was disqualified, but he made an award. to hold that a fresh arbitrator cannot be appointed to resolve the dispute between the parties, the very scheme of the Arbitration Conciliation Act would be reduced to futility. This is an important observation. For the same logic, we are of the opinion that even in the case where an arbitrator publishes an award which is eventually found to be illegal by the competent civil court, the authority to refer the matter to the fresh arbitration, in our view, must necessarily subsist. That is therefore allowed. So exactly my position. And that was allowed. So this is my answer to the respondent's argument that only once the arbitration is invoked, you cannot have that. Second thing is that this is a second reference. This same reference continues. That is my want to submit. Now, another argument arbitration clause subsists, clause stand extinguished when award made for the referred claims. That is what they said. But these are the same logic, same argument. Therefore, I don't want to. Now I want to only respond to Lordship was pleased to make an observation about Lombardy Engineering Limited, because that's the reason the latest judgment. Lordship was pleased to refer to both the parties that you look into these judgments and all. Yes. So that is Lombardy Engineering Limited versus Uttarakhand Jal Vidyut Nigam. That's the judgment. Can you? Citation. A citation. No, I can't copy. Because that was at that time. I can give you after. So I am reading paragraph 25 to 29 because that is dealing with some other subject, but set into the law, latest. But it is a continuation of a series of judgments. I can give those citations also, but para 25 to 29 also. This is on the first argument that the arbitrability should be decided by your lordship. That is the argument. Therefore, we are dealing with that argument. Para 25.
Yes.
In the wake of a few decisions of this court, the legislature thought fit to add subsection 6A to section 11 of the Act by way of an arbitration amendment Act 2015, hereinafter referred to as Amendment 2015, the same reads as under. The Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 of subsection 5 or subsection 6, we are in subsection 6, Lordship.
Yes.
Shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of the arbitration agreement. Just whether it's that they are admitting, admission agreement is there. Taking cognizance of the legislative change, this court in Duro Filagar versus Gangavaram Port Limited noted that post the 2015 amendment, the jurisdiction of the court under section 11(6) of the Act is limited to examining whether an arbitration agreement exists between the parties, nothing more, nothing less.
Yes.
So that is the word used. The entire case law on the subject was considered by the three-bench judge bench of this court in Withdrawal versus the Trading Corporation. That is also referred. I have. I'm sorry. The entire case law, I'm sorry, para 27. The entire case law on the subject of Trading Corporation, so and on overreaching principle with respect to the pre-referral jurisdiction under section 11(6) of the Act has been laid down. The relevant portion of the judgment is as under. Accordingly, we hold that the expression existence of an arbitration agreement in section 11 of the Arbitration Act would include aspect of validity of an arbitration agreement, albeit the court at the referral stage would apply the prima facie test on the basis of the principle set out in the judgment. In cases of debatable and disputable facts and good reasonable argument case, etc., the court would force the parties to abide by the arbitration agreement, as the arbitral tribunal has primary jurisdiction and authority to decide the dispute, including the question of jurisdiction and non-arbitrability. So my respectful submission is, yes, court has got power, But the first it will be before the arbitrator, thereafter it will come to the court. The discussion under this head, so and so, whose desired arbitrability can be crystallized as under. Then they are giving, kindly come to the bottom, 154.4. Rarely as a demur of this court may interfere at section 8 or 11 stage when it is manifestly and expressly certain that the arbitration agreement is non-existent. In our case, both parties agree there is an arbitration agreement. Invalid or the disputes are non-arbitrable, though the nature of the facet of the non-arbitrability would, to some extent, determine the level and nature of judicial scrutiny. The restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and to cut off the deadwood. The court by default would refer the matter when contentions relating to non-arbitrability are plainly arguable, when consideration in summary and proceedings would be insufficient and inconclusive when facts are contested. When the party of so and so, so and so. Now 28. Para 28. The limited scope of judicial scrutiny at the pre-referral stage is navigated through the test of prima facie review. This is explained as under. Prima facie case is the context of section 8 is not to be confused with the merits of the case put up by the parties which has to be established before the arbitral tribunal. So that I am not reading all those. Now I kindly come to para 29. Next page, para 29.
Yes, for a general rule.
Following the general rule and the principle laid down in Vidyadrolya, this court has consistently been holding that the arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. Then they are giving so and so, so and so. The parties were referred to arbitration as the prima facie review in each of these cases on the objection of non-arbitrability was found to be inconclusive. So this giving, but I have also given two more judgments, Lordship. That is NTPC versus SPML Infra Limited and Magic Eye Development versus Message Green Edge Infrastructure. These are all 2023 judgments, consistently holding the same thing. And Lordship has also relied on Supreme Court judgment in the Mala Pattajarji versus Indus Bank Limited, but that decision was on the other side for the reason there was no arbitration agreement. Otherwise, Lordship has settled, see that judgment, Lordship judgment also for a moment. That's page 39.
Or a compilation.
Compilation. Unfortunately, because of some change, the page 49 is coming first or second, I don't know. In my world, there is a binding problem. Kindly come to page 39.
Yes.
And para 10. This is Lordship judgment. Coming to the case of both so and so Limited, cited by the Lender Council for the petition giving conditions which are to be met, para 19 of the such judgment which is relevant for easy convenience reports here below. Where, this is the law which is laid down. Where a suit is filed by one of the parties to an arbitration agreement, that is under section 8, Lordship, where suit is filed against other parties to the arbitration agreement, and if the defendant filed an application under section 8 stating that the parties should be referred to arbitration, the court will have to decide, A, whether there is an arbitration agreement with the parties. You are agreeing them, there is an agreement with the parties. 2, whether all the parties to the suit are parties to the arbitration agreement. That is not relevant because we are not in a suit. Whether the dispute which are to be subject matter of the fall within the scope of arbitration agreement, they themselves say they are even ready to settle it by conciliation also. Whether the defendant had applied under section 8, that is not relevant. Whether the relief sought in the suit are those can be adjudicated, that is also not relevant for us. And 40, the first prerequisite that there should be an arbitration agreement among the parties, which would mean thereby a subsisting agreement. There is no problem here. The second requirement is that all parties in the suit should be also parties to the arbitration agreement. The other clauses will not be discussed as so and so, so on. In that case, because that's a different issue, and then the court held the otherwise for the petitioner, but the principle is the same, that first, nothing more, nothing less, whether there is an arbitration agreement, everything will go to before the arbitrator.
No, so limited, the court, the limited duty to examine.
Whether arbitration agreement.
Clause and whether it's been, what has happened after that. It went to arbitration, it was not done, whether second referral or not. And like I also your submission that you cannot see any arbitration clause that says that second referral is permissible.
Let them point out any arbitration clause where is the number one. And the last submission I am making is, but before that, I also make something. I am on a rejoinder argument. I did not produce any judgment other than already given to the other side. So there is no scope for a rejoinder to a rejoinder, because I am not reading anything new. Only what they have submitted, and I am not surprising them with any judgment. Only thing is what Lordship was fallen from Lordship, that there is a recent judgment. You look into both the parties, therefore I looked into, otherwise I did not solve. Now, last submission I am making is, the law says that if I give a notice to them to appoint an arbitrator or appoint your arbitrator, they can, and I give time, say 1 month time. I have given time, twice I have given time. If they did not appoint the arbitrator, still their Supreme Court says still their right will not go. But once a petition is filed, their right goes. So in support of that, I can furnish 2 judgments of the Supreme Court, which says that they have, their right is over now. So this Honorable Court will appoint the arbitrator on their behalf, so that the arbitrator tribunal can be constituted. I may submit 2 judgments in that support. That is,
we are not disputing that. This is settled principle.
We'll close the arguments today. Mr. Chandra, you want to reply?
I want to reply of this judgment.
I did not see anything more.
And for you, it may be.
Is there any practice rejoinder to rejoinder?
He wants to stop me before I make such a submission.
You are a senior lawyer. I cannot stop you. I cannot stop you. I have all respect for you.
Who can shut you down? Say, no one can shut you down.
Just give the citation.
I will give copies also.
Yes.
Unfortunately, I did not. That is, first is 2000.
Just give full citation.
2008 Supreme Court 151. Then 2006 Supreme Court. Taken copies, but unfortunately, see here. First is 2008 CC 151,
yes,
where para 6 Lordship first.
Invocation.
Invocation. Subsection 5 of Section 11 can be invoked by a party who has requested the other party to appoint an arbitrator, and the latter fails to make para 6 Lordship, para 6.
Yes.
Within 30 days from the receipt of notice. Admittedly, the instant case, the appellant has not issued any notice to the first upon seeking appointment an arbitrator. An application under subsection 6 of 11 can be filed when there is a failure of the procedure of appointment of an arbitrator. We are in 11.6. This failure of procedure can arise under different circumstances. It can be a case where a party who is bound to appoint an arbitrator refuses to appoint the arbitrator, or where 2 appointed arbitrators fail to appoint the 3rd arbitrator. If the appointment of the arbitrator or any function connected with such appointment is entrusted to any person or institution, and such person or institution fails to discharge such function, the aggrieved party can approach the Chief Justice or so and so. The appellant in his application does not mention under which section, so and so, that we are not. Therefore, the question to be considered is whether there was any real failure of the mechanism provided under the lease agreement, in other words, so and so. No, I am. In para 14.
17.
Actually 17 is more, but I will come down that. I am deeply obliged. 17. In all the above cases, therefore, the appointment of an arbitrator was not made by the opposite party before the application was filed under Section 11. In my case also, they did not file. Even now, they did not. Hence, all the above cases are not directly on the point. That means those cases where if appointment is made after the notice, also no problem, but before filing the petition. And therefore, the court held in the present case, the respondent made the appointment before the appointment application. In that case, appointment was made. Therefore, last para also. Hence, the appellant, while filing the application of Section of the Act, has no cause of action to sanction the same, as there was no failure of the agreement. In that case, there was no failure. In our case, it is totally failure. Even today, they did not appoint the arbitrator.
That is a contra judgment you have represented.
Yes, yes. But the principle has laid down that. Now there is second judgment, that is 2006 Supreme Court. But they are referring to the same judgment, and then they heard that this is also the two judgments I am submitting. And therefore, in fact, we have finished our argument. In a rejoinder argument, I did not say anything more than what is there. And
yes.
Thank you. I am deeply obliged.
One date may be given. On that day, I will just reply to the rule judgments which he has cited, and shall also file a brief synopsis.
Because actually the point is short, but only the interpretation. How you interpret that?
Yes.
A very interesting way you put it.
Yes.
That's only thing. I'm not sure. Yes. Okay.
37.
Deeply obliged, Lord.
Sir, one just 2 weeks time be given to me.
Okay, since you have taken enough time. But after, yes. You take a date from the court master. Okay. Yes.
We have filed our bullet points.
It was today?
Yes, Your
You
Lordship.
file also?
Yes.
Take it up. The bullet points have been filed to reserve judgment. This is regarding that?
Condonation.
Leave.
Yes, Your Lordship.
Okay. Yes.
Your Lordship,
Yes.
Before Lordship pass away with the records, I just want to submit one thing, Lordship. Lordship had last time had asked me where were the letters or the emails that have been sent by the petitioner with regard to her extending of her a leave from the outstation. My Lord, there are mails in regard to it, my Lord, at page 38, 39, 40, 41, where repeatedly, my Lord, they have been the petitioner have been sending mails to the respondents with regard to. And second thing, my Lord may look into this, my Lord. This order was passed on 15/10/2020. 2020, when this order was passed, my Lord, they had submitted earlier that this was online. It was never online. That is why we have shared an attachment that the resolution was never online and was never communicated to the petitioner. 15/10/2020. And they have taken the condonation of the dates prior to 15/10/2020, my Lord. Prior to 15/10/2020, my Lord, they have also a resolution was passed on 15/10/2020. So they could not have taken a retrospectively effect, my Lord. They have taken my leave before that. And from 15/10/2020, it was never communicated, my Lord. In the attachment which I have given, it has been clearly showcased that there was no such thing online.
What do you say? No?
My Lord, they have stated that the Board of Resolution was online. However, that Board of Resolution was not online, and I have given a certificate. I have given an attachment with my bullet points, where my Lord may see that
if you have clarification, I'll list the matter again. I'll examine it. Okay.
My Lord.
Yes.
And my Lord, this retrospectively thing, my Lord, may just note it down, because on 15/10/2020 they have passed a resolution, so they could not have taken my leave that were retrospectively to it. Because how would I know that such an order was being passed, my Lord? Much obliged, my Lord.
39.
Where's Mr. Marapan? What's the matter about?
Lordship. Lordship, this is regarding release of gratuity.
What happened? He's entitled.
Lordship, I pray for some accommodation, Lordship, in this matter.
For the state, this after 1 week, as the counsel of the petitioners are present. Yes.
Highly appreciated.